This is Andy Thayer with Graystack Media, and I'm talking today with three attorneys who are representing disabled clients in two very important long-running class action cases. For a couple of decades, they have been fighting for the right of people to be freed from institutional care and get the support they need in the community. So today we had a hearing about these long-running cases, people attempting to be freed into the community where they have more rights, they can control their lives. How do each of you feel about the progress of these cases?
Well, first let me state both of these cases are more than 20 years old. One is a class of physically disabled people, and one is a class of mentally impaired people who live in different types of institutions, either specialized mental health rehabilitation hospitals or in nursing facilities. These cases were filed in 2005 and 2006 to try to implement a Supreme Court decision that was issued in the late 90s, the Olmstead case. And by the length of the cases, that ought to tell you we are not thrilled and are extremely frustrated that this has been going on for a long time. I personally got involved in late 2007, so this has been kind of a labor of love going on 19 years. The Williams decree and the Colbert decree are both about 15 years old, and we're working with this judge and the state and a variety of court monitors to try to set these things right, to get people to be allowed to live where they choose to live, not where the state has told them where they have to live.
Yes, I think it is frustrating to see that we're at a stage of the case where we're not even moving people timely. There are a lot of people who they're supposed to be, if they want to live in the community, should be moved within a matter of months, and they're being stuck in these facilities for sometimes years. We're not even at a place where we can talk about making sure that everybody who wants to move and live in the community can do so in a timely basis. We're just talking about minimum numbers of people that the state has to make sure transition on an annual basis. And right now, because the state is going through a transition year themselves in terms of a new system, we're going backwards on that minimum number instead of forwards. So in many ways, it does feel a lot like one step forward, two steps back.
Ultimately, what this case is about is really making sure that the state fulfills its obligations under the consent decree to build sufficient community-based mental health services and housing supports to ensure that people get out of these highly restrictive institutions. And as we discussed today, we're tremendously concerned because this is not just about whether or not in any particular year a sufficient number of people are transitioning out. People's lives are at stake. These institutions are highly restrictive and in certain circumstances can in fact be deadly. So we are very concerned, and we need to make sure that the state is meeting its commitments to get people out in a timely fashion.
So Stephen, in court you mentioned that the high watermark for actually transitioning people into the community was 2015, and even then you weren't even treading water at that point.
That's correct. To put the numbers in some level of unfortunate perspective, these cases were filed in the 05-06 time period, and the consent decrees happened in a period around 2010 and 11. So we've been through the Blagojevich administration, the Quinn administration, the Rauner administration, and now the Pritzker administration. Don't know what the November elections will do, but every time there is both an administrative change or a re-election, as happened with both Blagojevich and Pritzker, there are changes in personnel at the various departments: Health and Human Services, Health and Family Services, Aging, the agencies that actually are defendants and are obligated to enforce the agreed upon decrees. Different people come in, learning curves, different approaches, some more hostile to the decrees, some less hostile. So there have been a lot of bumps in the road that have caused where we are. But at least in the Colbert case, which is what I referenced in 2015, we changed from calendar years to fiscal years, but that year, 2015, whether you look at calendar or fiscal, we moved more Colbert people than we have in any other time period. And here we are, give or take 11 years later, and we haven't quite gotten back to that level, which was insufficient, because as you heard in court today, there are many more than 1,000 people in the pipeline waiting to move, and new people move in every day.
So is the state pleading poverty for why they're not able to move people out? It seems to be a matter of number of personnel working, setting up resources in the community. That's a matter of money, I would guess.
The state has never said money is an issue. The issues are what specific obligations they have. And at least in Colbert, part of the decree was to create a cost-neutral plan. We agreed in the decree that to serve people in the community would cost no more in the aggregate than it costs to serve them in nursing facilities. We engaged Berkeley Research Group, who was gracious enough to do it pro bono, a very fine financial consulting firm. They tracked hundreds of people who moved out of nursing facilities into the community with all their supports and all of their needs being covered on average, and this is 2015 and 2016 dollars, the state of Illinois saved on average $10,000 a year a class member to serve them in the community as opposed to in the facility. So money is not the issue.
So if the state's money isn't the issue, what is the issue?
I mean, I think the issue is that the state is making choices about where to spend its dollars, and the state is really resistant to any suggestion that they might have obligations to provide ongoing, sustained financial support for people in order to transition them into the community.